All right, let's go ahead and call this meeting to order, the Governmental Affairs Committee meeting. And as is our normal history here, I'll open it up with a word of prayer. Let's pray. Most gracious Heavenly Father, we're honored and thankful to be able to come to this point in the session in a time where we celebrate so many freedoms. And just thank you for the guidance that you give to the committee members, to the entire General Assembly, Lord, as we go through difficult issues, as we work for the people. Just guide us and direct us in all that we say and do, that we would look for your wisdom and your will in everything that we do. In Christ's name, amen. All right, we're going to move forward with the Senate Bill 160. Chairman Balfour, are you in the room? Which microphone would you feel most comfortable at? All right. Welcome, Senator. Sorry we weren't able to accommodate this earlier. The floor is all yours.
Thank you very much, Mr. Chairman. Appreciate your hospitality in bringing this forward today. Senate Bill 160 is a bipartisan bill supported across the aisle in the Senate, passed 42-13. It's a very simple bill. It would allow the 41,000 Georgia employees who right now cannot participate in a political action committee the ability to be in a political action committee. Most states in the United States, and we have found Georgia is the only state in the United States that would have these most strict restrictions. Among the southern states, utility employees are treated like other employees when it comes to political contributions, including each and every one of our bordering states, whether it's Florida or Alabama or Tennessee or North Carolina or South Carolina. And frankly, Mr. Chairman, although I'm not a lawyer, the Supreme Court in its recent decision, which some would find controversial, would say that these indirect contributions by corporations have been found to be unconstitutional, and therefore our current law is unconstitutional. And I'll emphasize this one point, that not a penny of ratepayer dollars will be used in political contributions, and that's stated in the bill as well. I appreciate this time, and I would be willing to answer any questions that you might have on the bill.
Thank you very much, Senator. Any questions of the author? Representative Oliver.
Good morning, Senator.
Good morning.
You and I have had a brief opportunity to talk about a problem that's arisen in an interpretation of disclosure issues in relation to staff employees of the state of Georgia theoretically or allegedly not being covered by current disclosure requirements. I believe that that is a fix that needs to be applied in the remaining 3 days of our General Assembly. Do you agree with that in principle, that that's a disclosure issue that needs to be closed?
I think the disclosure issue needs to be fixed, but I personally would rather not see it fixed in this bill.
If this were the only bill that were available to offer that fix, would you oppose it at that point?
I think we need to come back and find out what other things we need fixed in the ethics law and come up with a bill next year.
Do you agree that a possible amendment to 160 would be appropriate to add to Code Section 21573 a specific language that public employees should be covered by disclosure as an amendment to 160?
I won't speak to that, but I will tell you that I'm in favor of full disclosure, always have been and always will be.
May I move to the body of your bill? You realize there's a different legal opinion on the import of United citizens.
I believe there are different opinions on it, yes.
And a fair legal opinion is that the Supreme Court has not prohibited an outlaw of corporate donations. You don't understand that that's an argument that people make? People
have made that argument as well, yes.
You and I were involved in the deregulation of the telecommunications system in the Senate, a very successful opportunity. You believe that AT&T is fully competitive now and the telecommunications industries are fully competitive now?
I believe they are.
Wouldn't it be appropriate, therefore, to limit 160 to only the telecommunication industry, since the remaining industries remain substantially monopolies, in my view, in Georgia.
Representative, I go back out of habit. I apologize. I think we're just going to disagree on that point. I think that would be one place to stop, but I believe that, as I mentioned earlier, Georgia is the only state in the United States, the only state of bordering states that do not allow employees to make political contributions. And I'll go to our state law right now on insurance. We don't let insurance companies give to the insurance commissioner, but we do let them give to the General Assembly. Same thing here. These would restrict contributions to the PSC, but would not restrict contributions to the General Assembly.
Thank you.
Representative Kidd.
Thank you, Mr. Chairman. Mr. Chairman from the Senate, two questions, if I may, and one point. One, I agree with Representative Oliver over there as far as the state employees go, but that's another day problem. You made the statement that no ratepayers' dollars would go toward these contributions, and that's covered in the bill. Will you show me where that's covered in the bill?
Page 2, lines 30 through 33, it says any contribution made by a public utility corporation regulated by the Public Service Commission to a political campaign shall not be included in any recoverable cost in any rate making or rate setting proceedings before the Public Service Commission. That's pretty clear to me.
Yes, sir. I've got that section underlined, because what that section says is that in a rate filing, contributions would not be used in a rate filing. It does not say contributions could be made out of rate dollars. In my opinion, contributions should be made out of the corporate dollars from the stockholders, not out of rate dollars. And this does not say contributions would not come out of rate dollars. It only says contributions would not be a recoverable cost. Is that correct?
I think you're being semantical and would make a good attorney on that, but I don't believe that is correct.
In fact, Mr. Chairman, is it not true that you specifically ensured that this language was in there for exactly that benefit?
Right. There were questions that began on this issue in the Senate, and when I heard about it, I thought it was taken care of to begin with, but I put that sentence in there specifically to make sure that it was very clear that this could never be used in any rate case.
I agree with it. Doesn't mean it can't be used in a rate case, but I disagree that it couldn't be used for contribution dollars.
Is that it, Representative Kidd?
Yes, sir.
Thank you. Representative Williamson. It's turned on. Oh, okay. Representative Morgan.
Thank you, Mr. Chair. Mr. Chair, just a question in terms of process. I'm thinking about teachers' unions as an example, where the members pay their dues, and some of their dues, as I understand it, can be used for political contributions. Would this be the same for employees of these companies?
Some of this gets back to federal law. It would be, I think, a little different in because of the way the laws are set up. You can only ask for political contributions from certain level employees at certain times of years. You can ask from executives almost any time of year. There's a lot of restrictions on how you can ask for political contributions, which I think is a lot more restrictive to corporate PACs than it is to teachers' unions, where a part of their dues just automatically go into it.
So this would be voluntary. The companies would ask their employees if they want to pay into the PAC, and they would choose to do so.
It would be totally voluntary. Okay. In fact, the legal requirements are very strict on how voluntary it needs to be.
Okay.
Yes.
Thank you.
You're welcome.
Thank you, Mr. Chairman. Just a quick question, Senator Balfour. Yes. Correct me if maybe I'm misunderstanding. Would corporations, say, for example, not to pick on AT&T, but would AT&T be allowed to give direct contribution to this under this bill, or would they only just create a PAC and then the PAC would distribute the money?
They could do either or both.
And that would apply to all. Now, EMCs the EMC can only form a PAC. Am I reading that correctly? Or an EMC could
An EMC could form a PAC. AGL could form a PAC.
Okay. All right, thank
All right, any other questions of the senator? Hearing none. Senator, thank you very much. If you'll hang around, we have 5 people signed up to give testimony on this. Robert Highsmith.
Thank you, Mr. Chairman. I'm Robert Highsmith with Holland & Knight, and we represent AT&T, and I'm here to speak in favor of Senate Bill 160. Senate Bill 160 really corrects an anomaly that's existed in Georgia law since the first passage of campaign contribution limits in the state, or campaign contribution regulation in the state. And very briefly, Mr. Chairman, the history of this is as follows. In the 70s, the federal legislature governing federal elections, Congress, Senate, President, established campaign contribution limits and elected to prohibit corporate contributions altogether, something the state of Georgia has never done. But when they did that, they said it's okay for a corporation to form a PAC, and it's okay for a corporation to provide administrative support to that PAC, as long as the funds that ultimately go to candidates are only from the employees and they're voluntary. And there are lots of rules at the federal level to make sure that those contributions are in fact voluntary. Senator Balfour mentioned some of those in his testimony. The Georgia's statute left out the clause. It's otherwise copied word for word from the Federal Election Campaign Act, but it left out the clause about when it was prohibiting utility contributions, it left out the clause that would allow utility corporations to establish PACs. So the anomaly that has created is that, and this is to Representative Thomas Morgan's question, that unions can give not only from PACs established, where voluntary contributions are made, but from the treasury of those entities. And corporations regulated by the Public Service Commission, such as telecom, electric utilities, cannot. And so, Representative Oliver, to your question, what the Citizens United case, and that's the recent Supreme Court case that was mentioned earlier, Representative Oliver is correct. The Citizens United does not specifically say that a ban on corporate contributions is unconstitutional. I do believe that's the direction that the court is heading in. But to Representative Oliver's very valid point, that is not what Citizens United said. What it did say is that you can't, just because of an entity's corporate identity, doesn't take away its free speech rights to engage in the political process. And what we have in the state is that certain corporations, those not regulated by the Public Service Commission, have always been able to make contributions. And other corporations and unions, for an additional example, cannot. And this bill corrects that anomaly, both for the purpose of establishing PACs so that the tens of thousands of utility employees in the state can participate in the political process at the same level that dues-paying union members can, but also so that they can participate in the political process as corporate entities, just like other corporate entities in the state. And exactly as Senator Balfour said, we have long prohibited entities that are directly regulated by an elected regulator from contributing to that regulator. Insurance companies can't contribute to the insurance commissioner. Folks who hold licenses, companies that hold licenses from the various examining boards under the Secretary of State's office can't contribute to the Secretary of State. All of the elected regulators in the state can't take money from the folks that they regulate. The prohibition on utility corporations has always been much broader and said they can't contribute at all, with all the effects of that Senator Balfour discussed. So what this bill does, it says utility corporations still may not contribute to members of the Public Service Commission who are directly regulating them, although frankly in much less measure than prior to the deregulation that Representative Oliver referred to earlier. But they can contribute to folks who are not directly regulating them, such as the governor, such as members of the General Assembly, to bring parity to the political process. Mr. Chairman, our time's limited. I'm not going to keep going, but I did want to be available as a resource to the committee, having formerly served on the State Ethics Commission.
Right.
And
we know you're a lawyer. You're being used to be billing by the hour, so we understand that. So we will. Are there any questions of the witness? And he will be around if we need him. All right. Having no questions, thank you very much. Neil Herring.
Thank you, Mr. Chairman, members of the committee. I'm Neil Herring. I'm a lobbyist for the Georgia chapter of the Sierra Club. The aspect of this bill, Senate Bill 160, that the Sierra Club finds objectionable is best explained by the examination of a document I have right here. This is an electric bill, modest bill for my home in Jessup. I paid this morning. On this bill, I see a line item, nuclear construction cost recovery, 92 cents. That's a rate that was set by the General Assembly. Y'all, as elected officials, wrote that rate. The Public Service Commission approved it, but they had no choice because the Public Service Commission is a creature of the General Assembly. You have regulatory power. This bill, as I read it, allows electric utilities like Georgia Power Company to contribute to your election campaigns, but you set their rates and the conditions of their service. I think that's objectionable. Under our system of government, the states have the right to create economic monopolies as a way to provide certain essential services to our citizens. We regulate the conditions of service and the rates under those monopolies. Allowing those monopolies to directly influence the regulators is simply wrong. And so that's my problem with this bill. Representative Oliver seems to have a remedy for my problem, and I hope that y'all will pursue it. That's all.
Thank you, Mr. Herring. Any questions? Thank you very much. Jim Keebler, Atlanta Gaslight.
Good morning, Mr. Chairman. I'm Jim Kibler with AGL, and I'm one of 1,200 of our employees in Georgia whose First Amendment rights have been disenfranchised by the current statute. It's wrong. In all of our other states of operation, our employees can gather, they can discuss politics, they can choose to support candidates or choose not to. And that, I believe, is a fundamental freedom that our founders guaranteed us as citizens in this nation. I would like to address Representative Kidd's question about the ratepayer dollars. The way rates are set in a proceeding at the Public Service Commission and in every Public Service Commission across the country, a utility comes in and presents its costs of service. And that's an accounting exercise, and the Commission set rules about what is in and what is out. And it agrees or disagrees with what the utility has presented and sets a rate that is designed to include the utility's cost of serving the public plus an authorized return. This bill ensures that, and I can't imagine any Public Service Commission would allow recovery in the cost of service for political contributions. None of our other states in which we operate allow that. But this bill ensures that in no way could political contributions be included in the cost of service for a utility to serve the public. It could only come out of the authorized return or the corporate profits. That's all I have, Mr. Chairman. I'm available for any questions.
I think you stirred a question.
Good morning.
Yes.
Have you ever perceived that Atlanta Gas did not have access to the political process nor have influence in the political process in Georgia?
Yes, ma'am, I have, at times. This is not about access. This is about our employees' right to participate in the political process. And
there's a fair legal dispute about whether or not that's a denial of First Amendment rights or not. You accept that as a question and dispute?
I accept that's an argument.
You genuinely don't think you have access to the political process in Georgia?
Ma'am, I'm not talking about my company. I'm here on behalf of 1,200 employees who cannot gather on company property and discuss politics. That's under the current law. That's the use of corporate property, and that's prohibited.
Thank you.
Thank you.
Any other questions? Thank you. Sally Clark.
Chairman, members of the committee, my name is Sally Clark, and on behalf of the Georgia Chamber of Commerce, I would like to express our support of Senate Bill 160. The Chamber represents more than 3,000 businesses across the state, and our utility members are the only companies who are restricted by current law to participate in the political process. We think this bill is about equality and fairness. We thank Senator Balfour, we commend Senator Balfour for his efforts in bringing fairness to the current campaign laws and ask for your considerable favorable consideration of Senate Bill 160. Thanks.
Thank you very much. William Perry. That's quite all right.
Thank you, Mr. Chairman and members.
As long as you don't plan on taking up a roost down there, it'll be all right.
No, sir. Thank you, Mr. Chairman and members of the committee. My name is William Perry, and I'm the Executive Director of Common Cause Georgia. We're taking issue with the bill for a number of reasons, and I just wanted to cover some of the issues that we feel haven't been fairly represented and is contained in this document that we handed out to you. First and foremost, the idea that the bill or that our current law is in any way unconstitutional. We've done a lot of research on this, and as far as we can find, we can't find one scholar or anyone who's willing to stand up and say, yes, Georgia's current law is indeed unconstitutional. We've provided you with a brief from one of our board members, Mr. Emmett Bondurant, who has successfully won a case before the U.S. Supreme Court and has worked a lot on the Citizens United ruling. We also have a number of, I believe it's 8 political science, not political science, but law school constitutional professors from around the state of Georgia who also agree that the current law is not unconstitutional according to Citizens United. We also threw in one from New Jersey, since that's the only other state that apparently has the ban on contributions from utility companies. The second point, which was recently mentioned, was the fact that the companies are, I guess, the companies that are the 2 states, Georgia and New Jersey, that don't allow this ban are the only 2 states in the nation that have anything like this. It might be true that we are the only 2 that ban it against utilities, but there are 22 other states that have stricter restrictions on corporate contributions than the state of Georgia. So to give the idea that 48 other states allow this isn't quite true. There's 10 that outright ban corporate contributions, and then there's 12 more that only allow contributions through PACs of any corporation. So their laws are more restrictive than ours. And finally, the idea that 41,000 employees or any 12,000 employees that were referred to today have less political rights or less rights to participate in the political process than anyone else. These 41,000 people still have the opportunity to vote, to contribute to campaigns, to volunteer to campaigns. It's only the one corporation that they work for that can't make those contributions. In fact, you'll see in Attachment D, there's a registration form for a PAC. I didn't realize until I started this research, it is so easy to form a PAC in the state of Georgia. All you have to do is spend about $300 on incorporating the group, and then you can collect and give away up to $25,000 before you only have to fill out one form for your PAC. So forming a PAC is not difficult. If those employees wanted a PAC, they could get together themselves and form one quite easily. These are the reasons why we're opposed to the bill, and I'd be glad to answer any questions.
Any questions of the committee members? Thank you very much.
Thank you.
All the testimony. Would the author like to address anything at this particular time? All right, just a moment, please. I'll recognize the chairman. Yes.
Proper time, make a motion.
This is that time.
I'd like to make a motion that Senate Bill 160 do pass with LC number 361861S SCS.
Second.
We have a motion and second. And a third on LC 361861S. And now is the time for discussion, and it looks like Representative Oliver.
At the appropriate time, Mr. Chairman, I'd like to offer an amendment.
If you would like to offer one, this would be the appropriate time.
I have distributed before the committee an amendment to Senate Bill 160, which adds a new Section 2 and renumber the remaining sections accordingly. Senator Balfour and I believe we both agree that disclosure of campaign expenditures, lobbyist expenditures, are highly appropriate. In the recent decision of the Ethics Commission to determine that employees are not covered by lobbyist disclosure, we believe is incorrect. The purpose of the amendment I offer is to include a Section 2 to Senate Bill 160 that would include public employees specifically as obligations for disclosure of expenditures. I don't believe that our committee needed to go through the process we went through early in the session to redefine salesman commission work if we did not at that time believe that public employees were covered in relation to expenditures. So I believe this amendment is consistent with the very first action we took as a committee in the beginning of this session.
Okay, we have an amendment Representative Oliver has presented. Do I hear a second? We have an amendment and a second. Is there any discussion on this amendment?
The only discussion I would offer, if I may, Mr. Chairman, is that I believe there is a bipartisan will to fix this problem, and that if we move this amendment forward, we will have at least one clean opportunity to do so. Other opportunities that may or may not be out there, I'd rather not gamble on. I'd like to have one sure opportunity to fix this problem.
Thank you. Representative Bearden.
Thank you, Mr. Chairman. Well, I think this is a very important issue. I think this bill is not the vehicle for that. There's been a lot of hard work on this bill. I think we need to move this bill as is and vote against the amendment.
Thank you. Representative Kidd.
Yes, Mr. Chairman, thank you. I support the bill. But being from a district in past has had thousands and thousands of state employees that were prohibited from participating in different aspects of campaigns is the reason I seconded Ms. Oliver's amendment. I would like to see it pass. If it doesn't, obviously, we can bring something back in the future. That's my rationale for the second and Oliver amendment is to make sure we treat give all state employees the opportunity. Thank you.
Thank you.
I have a question for the author.
Yes, go ahead.
Senator Balfour, you mentioned earlier that you were supportive of this but didn't want it in the bill. And so my question is, are you concerned that there's opposition and so it will hurt the bill itself, or you just believe it ought to be separate?
At this point, this is a clean bill, and I think I'd like to keep it clean because I think this is an important issue. I'm not sure how much this might weigh it down. I'm not in disagreement with the Representative Oliver on the notion that I've always been in favor of full disclosure, and I think that needs to happen, but maybe on another vehicle.
And let me respond to that, if I might. Representative Oliver brought this to my attention before we came in, and I appreciate her doing that. I had a brief opportunity to speak with Chairman Balfour on this issue, and I've also had an opportunity to speak to other members in the House. And although we never know what's going to happen during the last 3 days of the session, and I also agree with full disclosure, and I think that this is heading in the right direction, I would like to say that it's my understanding that there's going to be another opportunity to fix the present situation that we currently have. And so I would encourage you to pass this bill clean if at all possible, but that's just my opinion.
Can I ask one more question?
Sure.
About this amendment,
Sure.
Maybe to the author of the amendment. Just out of curiosity, does public employee include people that we hire as legislators? No. Okay.
I'm sorry. I was talking with a colleague. I didn't hear the question.
I was asking if public employee also included people that we hire in our legislative offices.
And my answer is no. I think I'm right about that.
Okay. Her answer is no. All right.
I think you answered my question. I was going to ask if House leadership had identified some other vehicle to fix this problem.
I cannot say that absolute, but I have talked with them several times about 160 as a vehicle, and as recent as right before the beginning of this meeting, this was not an amendment that I was told was felt that was needed at this particular time.
And Representative Oliver, I believe, wanted to respond to.
There are discussions going on. I agree with that. I would rather be secure. I would not like this opportunity to pass, and then at 11:30 on Thursday, I say, whoops, and go with, and also say, not unreasonably, but also say what Senator Balfour just says, well, we just need to fix this next year.
Thank you. One final question. Representative Powell, the other Powell.
Thank you, other part of the Powell caucus. Mr. Chairman, I don't have a problem. I've wrestled with this bill a little bit back and forth, and I see some of the wisdom passing this bill. But to my colleagues over on to my right, I'm pretty practical, and with this amendment, and I agree with that we need to correct this problem. If legislators and elected people are, if anything that is given has to be reported, and I certainly think that those state employees need to be treated out of the same loving cup. But when you pass legislation, sometimes you can add things to it that will give people a reason to vote for the overall bill. Does that mean if this amendment passes that this may very well pull some of the votes that might normally be opposed to it? Would this pull some of those votes into it? And I'd like to ask that question to Representative Oliver, maybe.
Campaign through excessive additional monies to the political process. I'm against it. However, I believe it's probably going to pass because I believe I'm a minority on that view, and I want to make sure that when it passes, it has something good to say to the people of Georgia.
So even though your amendment, if it passes, that you would still be opposed to the bill, even though that amendment would really be of a
I'm
great...
not going to vote for the principle of 160, but I believe it is destined to pass. I'm impressed. I'm very impressed with the support, the business support for this bill.
Okay. I think it's asked and answered. Any other questions or comments on the amendment that's been offered and seconded? If not, all those in favor of the amendment, let it be shown by saying aye. All those opposed, no. The noes have it. The amendment fails. Now we have before us Senate Bill 160 as originally passed the Senate, LC 36-1861. Any further discussion on the bill itself? Hearing no further discussion, all those in favor say aye. Aye. All those opposed? No. Bill passes with one abstention. Congratulations, Senator. Thank you very much. Meeting is adjourned.